Assalamualaikum. My name is Syakir Iman. I will present the introduction for this topic. So the topic that we get for the assignment is define the term non-bargainable subject and elaborate on 5 items that should not be included in the proposal for a collective agreement. So, what is collective bargaining? Collective bargaining, according to the Corporate Relations Act of 1967, is a negotiation with the goal of reaching a collective agreement. Furthermore, it is a produce in which the employer representative decide on the employee's composition, working hour, and other work and the circumstances. Next is what is non-bargainable? Non-bargainable is the term are those in which collective bargaining is prohibited, either because they must be included upon request or because they may not be included in the contract. Example of non-bargainable is the promotion of workmen, appointment of employee, the transfer of workmen within the organization, determination of service of worker by reason of redundancy or reorganization, and lastly the dismissal or reinstatement of a worker. So, what is a collective agreement? Collective agreement is an agreement in writing concluded between an employer and employees union on the one hand and employees union on the other, relating to the term and condition of employment and work of workmen or concerning the relation between such party. That's all from me. Now I will pass to my friend. Thank you.
I will explain to you guys about the transfer of workmen within the organization. The transfer of an employee in the organization is not included in the proposed collective agreement because firstly, it is one of the measures to ensure the organization is in order. At the same time, the transfer of employees is also a knowledge of learning and management in organization. This is because employee will gain new knowledge when in a new place that has been set through their own level of ability. With the skill they already have, management will pave the way for these potential ones to shine more in the job position that suit them. Next, the transfer of employees in the organization is not included in the proposed collective agreement because it also to improve working condition by providing employees who are good at using skill and competencies to help the organization achieve goals. This is because with an efficient and knowledgeable workforce, all organizational operation will be smoother and able to increase quantity and even be able to improve product quality. And the last one, the transfer of employees in the organization is not included in the proposed collective agreement because the transfer of employees is to avoid the existence of problematic employee in the organization to build and maintain the quality of the workplace environment. This is because a suitable workplace as well as a positive co-worker is an important element in building a strong work community in ensuring the continuity of the organization.
Assalamualaikum, my name is Iman bin MAZLAN. Today I will explain about 2.3, the termination of a service of a worker by reason of redundancy or reorganization. The word retrenchment is used to refer to redundancy of termination by an employee of worker deemed to be access to his requirement after a reorganization of his firm. Before retrenchment of the termination of the access, there must be redundancy or a labour surplus. Another important factor to examine when assessing if redundancy exists in company is whether the work continues to exist or whether the activity, although continuing to exist, require fewer personnel to carry it out. The restructuring or reorganization must result in redundancy of this discontinuation of work performed by the employee or a surplus of the employee. to carry out the specific job function. This item cannot be included because collective agreement is recognized as a symbol or proof of the harmonious relationship between an employer or employee union and a workman's union. The most common reason that employment is terminated is that the employee refers to a shortage of work. Redundancy is a legal term and includes all the reasons not attributable to the employee personally. Consequently, an actual shortage of work is not necessary for the employee to cite redundancy. Situation that can cause redundancy, the need for the worker has diminished or ceased. New system in the workplace. The job no longer exists because other workers are doing the work you carry out. The workplace has closed or is closing down. That's all from me. Thank you.
Hello and Assalamualaikum. I am DINI and I'm going to present about the dismissal or reinstatement of a worker. When an employee considers that he has been dismissed without cause or excuse by his employer, he may make representations in writing to the Director General to be reinstated in his former employment. If no reasons are supplied at the time of dismissal, the industrial court is required to conduct its own investigation to have the employer justify the dismissal, provided that any such grounds submitted by the employer were visible and operational at the time of the dismissal. Secondly, the representations may be filed at the office of the Director General nearest to the place of employment from which the workman was dismissed. The department may set a date for the conciliation, at which both the employer and the employee are called for the goal of reaching an agreement. Next, the words "to be reinstated" clearly indicate that the primary remedy in a claim for unfair dismissal is reinstatement. As an example, that if successful, the employee should be given his job back and continue to work for the employer. The reinstatement remedy means that you will be reinstated to your previous position with your employer from a date between your dismissal and now.
So basically, in carrying out the collective agreement, it actually indicates the employer responsibility, where the employer has a managerial rights over its workers, such as employers have authority to act or make decisions that affecting their employees and etc. So back to the discussions. So the worker duties or tasks that are allocated or assigned in a way that is compatible with the terms of service. It is one of the rights prerogative of employer matters that cannot be touched or disputed by the trade unions. Means that these employers must present the employees with explicit terms and its conditions, as well as with explicit term and condition of employment, as well as any we can say any particular tasks, right? That may be allocated. Alright, all these tasks must be provided by the employers with complete information, so that employees have because they have enough information to perform that task. Okay, they know what to do, they know their jobs. Alright, so of course all these terms and conditions are based on the regulation and law that's in effect under Employment Act of 1955. Right, so all the terms and conditions of agreement that have been reached cannot be questioned, because it's one of the rights of the employees, and the employees we can say is entitled to abide by it. Okay, so I add one more thing, which is if there's any disputes regarding the job classifications, which is one of the management function, isn't it? So the court can be consulted. So we might already familiar with the terms collective bargaining, right? So this one is collective agreement. Means that after collective bargaining has been reached or agreed by the parties involved, so then the collective agreement is formed. Where is it a written agreement between the employers and also trade union that covering all the terms and conditions of employment that has been reached by the both parties. Of course, in order to reach collective agreement, it must go through some of the process. We can say that it's a very complicated process, but yeah, to ensure we can solve any dispute or conflict that happen, that occur, such as salary, maybe job description or whatsoever. So it must go through some process first. Okay, first of all, as you can see, it must go through negotiation. All right. Negotiation is must between the employers and also, you can say, employees unions or employees unions or employers. So they may invite each other to initiate negotiation. Of course, if they, to make negotiation happen, there must be, any party must make a first move, right? Usually in negotiation process, usually a draft in writing along with proposal is needed in to reach to the collective agreements. Okay, there must be some set of date, okay, and negotiation of the terms of the collective agreement that needs to be agreed. Okay, if this can be settled without any disputes. Okay, so we can see that collective agreement has been reached between both parties. But if not, cannot be settled this, so we move to the next steps. The next process is through KPPM. Employers trade union, they must submit a complaint or they must report to the KPPPMs, right? Triple P, Ketua Pengarah Perhubungan Perusahaan Malaysia in Malay. Okay, so they can to settle the dispute happens. So if cannot be settled, any party can report to JPPM, which means department under KPPM. Okay, so there's the one will tackle the issues where they will settle that through peace negotiation. And then if settlement also cannot be reached, we can say KPPM, they will inform YB, the Minister of Human Resource. Okay, after examining all the facts of the disputes, the YB, the Minister, they will decide whether it's appropriate or not to be referred to the industrial court. And finally, the last process, as you can see, the industrial court will decide and issue a decisions that's related to the disputes. Okay, and the decision by the industrial courts will be binding on the party involved. All right, so they must follow all the rules and regulations that already been set by the industrial courts. That's all.
For the analysis, according to the case relating of this topic is case Kesatuan Sekerja Pembuatan Barangan Galian Bukan Logam versus MCIS Safety Glass Sedian Berhad. As the court state, employees, some of whom have worked for the company for 16 years, have not been paid on salary scale, a wage scale with minimum and maximum salaries for each salary group, as well as an annual salary increment should be in place. The court held to implement the productivity linked wage system, also known as PLWS, under collective agreement. As conclusion, the PWS would be the best system to use in the organization to implement a performance-based salary wage system.
So, for the conclusion is, collective bargaining is one of the most influential techniques to improve labor rights and working conditions. Collective bargaining is a technique used by trade union to negotiate and bargaining for improved working conditions for its member. Furthermore, we might deduce that there is an non-bargaining aspect of him in the bargain. The 5 items in non-bargaining part have already been addressed in detail as to why they are not included in the collective bargaining. Aside from that, the 5 issues are already outside the scope of collective bargaining. The conclusion can be made for collective agreement is collective agreement can benefit both employee and business in the collective agreement. The party may agree on a mutual advantageous condition. Employees are determined better working and social protection regulation which inspire them to form or continue labor legal relationship, while the employer increase a work quality, competitiveness and work outcome by utilizing its most important resource. That's all from me. That's all from our group. Thank you for watching.